felt threatened. He acted in self-defense, but what is self-defense under the law?
Joining us now to talk more about this is Eric Subin, criminal defense attorney. Good morning to you. Thanks so much for being here.
Good morning, guys. Thanks for having me back.
And really, this isn't just about self-defense, because self-defense is here at one standard, but also the other standard is the use of deadly force. That's a higher standard. So explain exactly what the law is.
Right. The justification of the use of self-defense is subdivided into two parts in the statute. The first is the use of physical force in defense of yourself or property, which would be punching or kicking or pushing or whatever's needed.
So I'm on the street, you attack me, I can punch you, and the law would say I'm okay.
Right. You're not going to get charged with assault under those circumstances because you acted in self-defense and your use of physical force.
Okay.
But the second part of the statute is the use of deadly force. It's a much higher burden for that. You have to be able to show that it was a reasonably held belief that you were under an imminent threat of death to yourself or to a third party. So if I'm reaching for a gun and you shoot first, then I'm justified in that shooting, and it was self-defense, and the use of deadly force will be justified. But if you're coming at me with your fist and I pull a gun and shoot you, that's not going to qualify under the deadly force provision of the self-defense statute.
Let's talk about him carrying a gun. Can he carry a gun as a retired police officer?
Yeah, it doesn't even have to be a retired police officer or a corrections officer to carry a gun. You can apply for a CCW permit, a concealed carry weapons permit. They're very, very, very difficult to get in New York City because it's a very high standard, but being a former law enforcement officer, he's qualified.
He had one, yeah.
Let me ask you this. This man, he is almost 70 years old. You have these two men that he is in this confrontation with. One's in his 20s, the other guy's in his 30s. Can he make the argument, I'm sure his defense will make the argument, that he was in fear of his life, he has a gun, these guys knew he had a gun, and they're in a scuffle, so perhaps he was in fear of his life because of that. Is that an argument or no?
I imagine that's the exact argument he's probably going to make. That the gentleman who was involved in the confrontation with Mr. Grooms is half of his age. Granted, Mr. Grooms seemed in the video to be a much larger man than him, but he'll say the guy was attacking me, menacing me, had punched me earlier on the subway. Right. The confrontation continued from the platform to the mezzanine, and when he continued to attack me, I pulled my gun to scare him away, and it went off.
So your rights are you have to prove that you were going to be threatened death.
Yeah.
Death, basically.
Right. An imminent threat of death to yourself or to somebody in your close vicinity.
Let's talk about this McDonald's video. I can't stand it, but your thoughts on it? Oh, have you seen it? Oh,
I did see the video. Yeah.
All right, your thoughts on it?
It's a gang of young teenage girls beating up another teenage girl. And I know that no charges have been brought yet because the victim, shown in the middle of the video there, hasn't come forward. So.
But wait a minute. But why? Look, all of us have eyes. We can see a crime is happening in this video. Why do police and prosecutors need to wait to charge somebody for the victim to say, okay, that was the people, when we see it ourselves?
Well, they can't just go around charging people with assault or gang assault sort of willy-nilly. They have to be able to prove their case.
And if nobody's talking, nobody's talking.
Right. So even though you've got the video, you still have to be able to get it admissible into evidence, meaning have the person who shot the video say, I shot this video and it's a fair and accurate depiction of what I purport it to be, and I can point out that these are the people involved. At that point in time, then maybe the district attorney's got enough to at least go for a grand jury indictment for gang assault in the first degree or something like that.
Yeah.
And then if the victim or witnesses aren't going to come forward for trial, the people involved in the beating, the 15 or so girls that are there beating up on the other girl, could plead to a lesser offense, assault in the third degree, which is a misdemeanor.
It's funny because you see it's not funny, but you see the video, you see all of them as clear as day. You know what I mean? He just all as clear as day. So
right, but a jury would never actually see the video if it can't be authenticated into evidence. A judge would dismiss the case.
All right, Eric, thank you so much for your perspective. Of course, for up-to-minute developments on all of these stories, go to our website at Pix11.